Hello, my name is Henry. What can I assist you with today?
I'm renting an apartment and my landlord is not making necessary repairs.
First, we need to look at your lease. Do you have a written lease?
Yes, I have a written lease. But why do you have to look at the lease?
Every case dealing with landlord-tenant issues is different because not every tenant has the same lease. Your lease may tell us who is responsible for maintenance issues, or it may not state anything regarding maintenance. The contents of your lease will determine what steps you can take. Everyone's lease is different, so you should consult an attorney with any specific questions.
My lease does not say anything about maintenance. How do I know what the landlord must do?
Landlords are required under Florida statute to comply with all requirements of the building, housing and health codes. Seminole County and certain cities within the county have codes that must be followed by the landlord. The landlord must comply with these codes. If the lease does not state otherwise, the landlord must also make reasonable provisions for pest extermination, locks and keys, clean and safe common areas, garbage removal, functional heat during the winter, running water and hot water. There are different requirements for duplexes and single-family homes, so if you rent one of those you should consult an attorney. You should also be aware that the tenant also has maintenance duties to follow.
What kind of maintenance duties do I have as a tenant?
Under Florida statute, the tenant has several maintenance duties. First, the tenant must also comply with the building, housing and health codes. Second, the tenant must also keep their residence clean and sanitary by removing all garbage and keeping plumbing fixtures clean and in good repair. Third, the tenant must reasonably operate all electrical, plumbing, sanitary, heating, ventilating, air conditioning and other facilities and appliances. Fourth, the tenant cannot damage or remove any portion of the premises nor permit any person to do so. Lastly, the tenant must not unreasonably disturb their neighbors.
How do I know if the problem I am having is a code violation?
The type of property maintenance problem will determine which code may apply. If the problem is structural, like rotting wood or a leaky roof, it could fall under the building or housing code. If the problem is related to health, like mold or sewage, it may fall under the health and building code. The best thing to do would be to contact your code enforcement office and file a complaint. Not all code enforcement offices assist tenants, so you need to call your code enforcement office to see if they can assist you. Some code enforcement offices do not deal with mold complaints, so if you live in Seminole County, you should contact the Seminole County Health Department. The health department can assist you in testing for mold, but they charge a fee for their services.
How do I know which code enforcement office to contact?
Each city and the county have their own code enforcement procedures, so you should contact the county or city if you have any questions and to determine whether they will do an inspection.
Is there anything else I can do besides contacting code enforcement?
The first thing you should do is try to work with your landlord and try to solve the problem. The landlord may be aware of the property maintenance issue, but may not be able to fix it right away. Remember to document all communications with your landlord and keep copies of any letters between you and the landlord.
Is there anyone who could help me work out the problem between me and my landlord?
Yes, the Orange County Bar Association has a free citizen dispute mediation program that can help mediate landlord-tenant problems. The service is free for Seminole County residents. Both the tenant and the landlord must agree to do the mediation, and the parties must travel to Orange County for the mediation.
Is there anyone else I can contact besides code enforcement and the Department of Health?
The Division of Hotels and Restaurants may be able to help in certain instances. The Division of Hotels and Restaurants only deals with certain matters pertaining to apartments. You can contact them to determine if you can file a complaint.
What if I do all of these things and the landlord still will not fix the property maintenance issues?
After you have tried all of these avenues with no success, there is one more thing you can do. But before you pursue this option, you should first consult with an attorney to help you determine whether this option is right for your situation. This final option is to write a letter to the landlord demanding that the property maintenance issue be fixed. First, the attorney will look at the property maintenance problem you are having and determine whether it deserves further legal action by determining if it violates a lease provision, is a code violation, or violates the landlord's maintenance duties. It is important to contact an attorney at this point to determine whether your property maintenance issue is serious enough to permit a letter to the landlord. If the attorney determines that your property maintenance issue is enough, they can write a letter to your landlord.
Does the attorney have to write the letter, or can I write one?
You can write your own letter. The letter is known as a 7-day notice to withhold rent. The Florida Bar has a form letter on their website that you can use. The form you would use is Form 4, Notice from Tenant to Landlord Withhold Rent for Failure of Landlord to Maintain Premises. This letter tells the landlord what repairs need to be made and states that if the repairs are not made within the 7 days, then the tenant will withhold a portion of their rent. If you use the form, please carefully follow the instructions for this form before you fill out the form. You should specifically state all the repairs that need to be made by the landlord, as the directions for this form state the amount of rent that the tenant withholds should be an amount that is proportionate to the amount of rental value lost. In other words, the more severe the property maintenance problem, the greater the percentage of rent withheld, but if the problems are less severe, the percentage of rent withheld should be less. If you have any questions concerning what percentage of rent you should withhold, you should consult an attorney.
Can I just write the 7-day notice letter and not contact code enforcement?
You could just send a 7-day notice letter, but it is a good idea to contact code enforcement before you send the letter. If code enforcement investigates your complaint, they may determine whether the property maintenance problem is a code violation. If code enforcement finds a code violation, this may help you demonstrate that your 7-day notice is appropriate. You can also attach any reports and pictures to the 7-day notice letter.
When and how should I deliver the 7-day notice to my landlord?
In order to withhold the next month's rent, you must deliver the 7-day notice before your rent is due. If you hand deliver the 7-day notice, you must deliver it at least 7 days before your rent is due. You can also mail the 7-day notice, but be sure to use certified mail so you can prove that the letter was delivered to the landlord. Also keep in mind that if you mail the 7-day notice, you have to add 5 extra days for mailing. So if you mail the 7-day notice, you must mail it 12 days before your rent is due. It is also a great idea to attach copies of any documents from code enforcement or the Department of Health. Remember to keep a copy of the letter and all attached documents for your records.
What if the landlord does not fix the problem?
If the landlord has not made any effort to fix the property maintenance problem after the time period expires and the tenant remains at the residence, the tenant is still obligated to pay the amount of rent listed in your 7-day notice letter. The reduced rental payment is proportionate to the lost rental value caused by the landlord's failure to fix the property maintenance problem.
Will the reduced rental payments continue until the end of my lease?
The reduced rental payments will continue until the landlord begins making an effort to make the necessary repairs. After the repairs are made, the full rental payment should be made. If you are not sure whether the landlord's efforts to repair are sufficient, you should consult an attorney.
What should I do with the portion of the rental payment that I'm not paying to the landlord?
You should put this portion of the rental payment into a separate account, or at the very least keep the money available. It is important to keep the money available just in case the landlord files an eviction case against you.
Can the landlord evict me for paying only a portion of my rent stated in the 7-day notice?
It is possible. The landlord may ignore your 7-day notice and try to evict you. But before the landlord can file an eviction case against you for non-payment of rent, they must give you a 3-day notice to pay all of the rent that is due. If the landlord does this, you should consult an attorney with any questions and let them know about the 7-day notice that you delivered to your landlord. If an eviction is filed against you, you must put all the rent that you did not pay to the landlord into the court registry. If you do not have all the rent money to deposit, the court will rule against you. This is why it is so important to have the money that you did not pay to the landlord available. An eviction complaint is a very serious matter that may affect your credit report and your ability to rent in the future.
What if the tenants cannot afford an attorney?
If a tenant cannot afford an attorney, they should visit their local legal aid office and see if they qualify for their services.
Thank you for your help.
You're welcome. Remember that every case is different and unique, and if you are not sure what to do or you have any questions, you should consult an attorney. Always remember to document all communication with your landlord and keep all the proof of property maintenance issues. The more proof and documentation you have, the better chance you will have to succeed in your case.